If you own a braced pistol, a suppressor, or you've ever dealt with confusing ATF paperwork, 34 new rules dropped on April 29, 2026, and most explanations of what actually changed are either wildly overstated or missing the single most important detail: which rules are actually in effect right now, and which ones are still just proposals sitting in a public comment period. This kind of sprawling regulatory announcement is exactly where confusion spreads fastest, because a headline count of 34 rules invites people to assume all 34 are equally real, equally final, and equally something they can act on today, when the actual mechanics of federal rulemaking work nothing like that. I'm going to walk you through exactly what changed today, what's coming later this year if the proposed rules survive their comment periods, and what you should actually be doing differently right now based on your specific situation, whether you own a braced pistol, a suppressor, or you're just trying to understand where federal firearms regulation actually stands after the largest single-day regulatory action in ATF history. Before we get into it, if you want practical, accurate guidance about what's actually changed instead of a list of 34 bullet points with no context about which ones matter to you specifically, subscribe and turn on notifications right now. This is exactly the kind of sprawling regulatory announcement where the details determine everything, and getting the timeline wrong could mean you're operating under outdated assumptions either way, whether that means missing out on a protection you actually already have, or assuming a protection that hasn't actually taken effect yet. Let's get into exactly what you need to know. Here is the most important thing to understand before anything else. Of the 34 rules in this package, only 7 are final rules, meaning they're either already in effect or take effect immediately upon Federal Register publication. The other 27 are proposed rules, meaning they're not law yet. They're subject to public comment periods running as long as 90 days, some extending into late July 2026 and beyond, and the final version that eventually takes effect could differ from what was initially proposed, depending on the comments the agency receives. Treating all 34 as if they're equally immediately in effect is the single biggest mistake circulating in coverage of this story right now. The first segment is what actually happened with pistol braces, because this is the change generating the most excitement and also the most confusion. The package includes a proposed rule, not yet final, to formally rescind the 2023 pistol brace rule, the regulation that had attempted to reclassify a huge range of stabilizing braces as effectively converting pistols into short-barreled rifles subject to NFA registration. Here's what actually matters practically. Federal courts had already blocked enforcement of the 2023 rule well before this announcement in litigation, including a case called Mock versus Garland, meaning the rule has been largely unenforceable for a while now, regardless of this new proposal. What this April 29th proposal does is formally remove the specific regulatory language from the books and restore definitions more closely tied to the underlying statute, essentially making official what courts had already forced into practice through injunctions. If you own an AR-style pistol with a brace, you were very likely already operating in a legally safer position than you might have realized before this announcement, thanks to those earlier court rulings, and this proposed rule, once finalized, formalizes that position rather than creating it from scratch. It's also worth understanding that even after this proposed rule is finalized, the agency has indicated in court filings that it retains some case-by-case authority under the underlying NFA definition for configurations that genuinely appear designed to function as a shoulder-fired weapon despite technically being labeled a pistol, meaning the broad reclassification scheme is gone, but the agency hasn't entirely abandoned the ability to evaluate genuinely unusual configurations on their own individual merits. The second segment is what changed immediately, today, without needing to wait for any comment period, because these are the parts of the package you can actually rely on right now. The NFA tax on suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons is currently $0, but it's worth understanding this wasn't actually new law created by the April 29th package at all. The One Big Beautiful Bill Act, signed back on July 4th, 2025, had already zeroed out that transfer and making tax effective January 1st, 2026. The April 29th rulemaking simply updated the Code of Federal Regulations to formally reflect a statutory change that had already happened months earlier. If you filed a Form 4 or Form 1 for a suppressor or short-barreled rifle anytime after January 1st, 2026, You owed nothing in tax, and that remains true regardless of this new package. If you paid the tax before that date, there is no refund mechanism built into the statute, meaning that money isn't coming back regardless of any of these regulatory changes. It's also worth being precise that this $0 tax applies specifically to suppressors, SBRs, SBSs, and AOWs, not to machine guns or destructive devices, which still carry the full $200 NFA tax exactly as before. The third segment is what else is actually final, and in effect right now, beyond the tax update. The package eliminated the requirement to notify your local chief law enforcement officer when filing certain NFA paperwork, a long-standing step that had frustrated many applicants, particularly those in jurisdictions where local law enforcement was slow or unresponsive to these notification requests. It also replaced an indefinite records retention requirement for Form 4473, the form completed at every licensed firearm purchase, with a defined 20 to 30-year retention window instead, and established the Easy Check system as the accepted method for federal firearms licensees to verify a transferee's license status electronically, eliminating the need for certified paper copies in that specific verification process. The fourth segment is what's proposed but not yet final, beyond the brace rule, because this is where you need patience rather than immediate action. The package proposes modernizing electronic record-keeping systems, including electronic versions of Form 4473 and acquisition and disposition records for licensed dealers. It proposes clarifying standards for how state-issued firearms permits qualify as alternatives to a NICS background check under existing federal law. And it includes a range of other clarifications and adjustments across the reduced burden and aligned categories that touch import rules, licensing procedures, and administrative processes throughout the firearms industry. None of these become binding until their respective comment periods close and the agency issues final versions, a process that historically can take months and doesn't always result in the exact language originally proposed. The fifth segment is what's notably absent from this package, because the gaps matter just as much as what's included when you're trying to understand where things actually stand. Frame and receiver regulations, one of the most heavily litigated and contested areas of recent ATF policy, are not addressed anywhere in this package, a gap multiple industry analysts have specifically flagged as deliberate rather than accidental, likely reflecting either separate, ongoing litigation. The agency doesn't want to complicate through new rulemaking, or a strategic decision to handle that fight through a different process entirely. Suppressor classification under the core 1934 NFA framework itself also wasn't touched, meaning suppressors remain fully regulated, NFA items requiring registration, just without the previous $200 tax attached, an important distinction if you've seen any marketing suggesting suppressors are now completely unregulated, which they are not. The sixth segment is what you should actually do right now, based on your specific situation. If you own a braced pistol, understand that the practical legal risk was already significantly reduced by prior court injunctions before this announcement, and this proposed rule, once finalized, formalizes rather than creates that protection, meaning you should continue monitoring the rule's progress through its comment period rather than assuming it's already fully final law. If you're planning to purchase a suppressor or short-barreled rifle, understand that the $0 tax has been in effect since January 1st, 2026, independent of this specific announcement, and continues to apply regardless of the broader 34 rule package's status. If you're a licensed dealer navigating record-keeping requirements, watch specifically for the modernization proposals covering electronic 4473s and the new retention window, since those changes affect your compliance obligations directly and are still moving through their public comment process rather than being settled today. Let's step back and name what actually matters most about this entire announcement. A 34 rule package sounds, and in some ways genuinely is, historic in scale. But the practical reality for any individual gun owner depends entirely on which specific rule affects your specific situation, and whether that rule is one of the 7 already final or one of the 27 still working through public comment. Treating this announcement as one single uniform event that changed everything all at once misses the actual mechanics of how federal rulemaking works, mechanics that determine exactly when and whether any individual piece of this package actually becomes binding law you can rely on. It's worth understanding why this final versus proposed distinction gets lost so easily in how stories like this spread. A headline announcing 34 new ATF rules is inherently more dramatic and more shareable than a headline explaining that 7 rules are final, while 27 remain pending public comment through the summer, even though the second version is the one that actually helps you make good decisions. Retailers, advocacy organizations, and content creators across the political spectrum all have their own reasons to emphasize the dramatic version of this story, whether that's generating excitement to drive sales, rallying supporters around a perceived victory, or simply chasing the engagement that comes with a bigger, bolder claim. None of that makes the underlying rules any less real or any less significant. It just means the responsible thing to do is verify the specific status of whatever rule actually applies to your situation before treating it as settled, rather than assuming the entire package moved as one unified block the moment it was announced. If you take one thing away from this breakdown, let it be this. Before you change any behavior based on a claim about what the ATF's new rules allow, confirm specifically whether that particular rule is final or still proposed, because that single distinction is doing more work than almost anything else in determining what's actually safe and legal for you to do today. The 7 final rules are real, and you can rely on them now. The 27 proposed rules represent a genuine, likely direction for federal firearms policy, but they are not yet the law you can act on, and treating them as if they already are is exactly the kind of mistake that headline-chasing coverage of this story keeps encouraging. If this helped you separate what's actually changed from what's still pending, share it with someone confused by the headline count of 34, subscribe so you catch each proposed rule the moment it actually becomes final, and I will see you in the next one.